Hello, everyone. After the tragic loss of my son Kenley in 2019, I had to navigate through a maze of legal red tape and a narcissistic DA who not only was indifferent to victims' rights, but deliberately and forcefully denied my rights. The more my rights were being denied, the more I became weary that my son's case might be the one that was, shall we say, would have seemed less significant compared to others because I lived in another state and I am a widow and Kenley was my only child. Yes, that was the DA's issue. I'm a woman and I had no husband and I only had one child. Oh yes, I was senile too. But you know what? There are wonderful, wonderful caring DAs. And what happened to me is very, very rare. A wonderful DA working in the same office noticed what was happening and ensured that my case was handled appropriately. To this day, I thank her so much for that because I'm sure who knows what kind of trouble she could have gotten into. The district attorney has the authority to propose a plea deal without needing approval from a victim. Now, this is a legal method used to clear cases from their congested agenda. And yes, they have a lot of cases, especially now. As a mother, the legal system is confusing, especially to the extent to which a defense lawyer might go to quit their client, regardless of the overwhelming evidence against the drunk, like in my case. The Sixth Amendment guarantees that everyone should have a defense, even if they cannot afford it. I understand this because most of us could not afford the exorbitant fees charged by defense attorneys. Now, the man who killed my son was found at the scene of a crash and was strapped into the driver's seat. And get this, my son's car was parked in a safe rest area where he was sleeping with his dog in a parked car. Now, he did the right thing. He pulled off the road to sleep when he became sleepy. Parts of the defendant's car and even his children's coloring books were discovered inside my son's wrecked vehicle. It's like evidence paints a picture all its own. Yet, here we are, navigating through a system that seems to have its scales tipped not toward justice, but toward technicalities and loopholes. The defense in my son's case had no chance of securing a not guilty verdict. So they had to explore alternative strategies to acquit their client. Here is where it gets maddening. When a defense plea wasn't accepted, dismissing the blood work was the next common tactic. Of course, the DA has much more work to do, and the cases are piling up, which could mean a plea deal offered by the DA. First, the defense can file a motion to suppress, arguing the way his blood sample was collected was substandard. Then there's the whole process of how blood was drawn. Was it done right? Was the person who took it qualified? These are questions a lawyer can raise. They can also deep dive into the journey his blood sample was taken from the drunk's arm to the lab, suggesting there might have been some slip-ups or even tampering along the way, which could mess up the results. Anything. Now, it doesn't stop there. The actual blood test itself isn't off limits for questioning. The defense attorney can examine the equipment, the folks running the test, and how it was handled. If the blood drawn without proper warrant, That's another angle they might explore, arguing it stepped on the drunk's constitutional right. Really? What about my rights? What about my son's right? What about your children's rights? It's always the criminal's rights. Always remember that. Everything is on the criminal side. It's important not to direct frustration at the police. Please don't do that. The police prioritize the driver's medical care to assess their level of intoxication. They gather details at the scene, noting any signs of impairment like slurred speech or confusion, which are vital for proving the driver's condition. If a breathalyzer isn't possible, a warrant for blood test is sought to measure alcohol or drug levels accurately. Studies provide a solid foundation to hold the drivers accountable for DUI. Now, in the state where my son's crash happened, the authorities usually prefer to get a warrant before conducting a blood test. But I learned that there are exceptions, particularly in urgent cases, if waiting for a warrant might destroy the evidence because the substance alcohol might no longer be detectable in the person's system. Now, the police might bypass this step. This approach depends heavily on where the crash occurred and the details of the incident. In my case, this is what happened. The drunk who killed my son was too drunk to give his permission to provide blood work. He was also too drunk to take the standard tests. So if this evidence had been thrown out, it would have benefited the drunk and possibly got him a non-guilty verdict. But again, fortunately, I had a terrific police officer who made sure that this did not happen. My journey underscores the official and critical importance of advocacy, persistence, and the need for a legal system that better supports victims and their families, ensuring our rights are not sidelined by protocol, bottlenecks, or lack of empathy. Let's unite to guide others through their darkest moments by sharing our stories. By doing so, we can empower those navigating the legal system to pursue justice for our loved ones. Together, we can make a difference. Please share your stories and help other victims going through the worst time in their life. Together, we can help others navigate the legal system and get justice for their loved ones too. Remember, in the face of adversity, we're stronger together. Let's keep the conversations going for Kenley, Marshall, and every soul taken too soon. Our journey towards justice and healing continues. I am the proud mother of Dr. Kenley Gene Raney, who, along with his faithful friend Marshall, was killed by a drunk driver as they slept on January 25th, 2019. Thank you.